Hello again, everyone. Welcome to Washington Gun Law TV. I'm Washington Gun Law President William Kirk. Thanks for joining us. Hey, we're going to head out to the East Coast, talk about a state that we actually haven't spent a whole lot of time talking about, and I candidly do not know why, because when it comes to preserving the inalienable rights of its citizens, this state candidly sucks at it, okay? Now, when we're going to talk about states who just flat out hate the lawful and responsible gun-owning residents within that state, you know, Illinois comes to mind, California, certainly the king of crazies, New York, Massachusetts, Washington, Oregon. But today we're going to talk about a state that candidly probably hates its gun owners as much as any state in the nation, and that, of course, is New Jersey. Now, as some of you may know, and many of you may not, New Jersey arguably has the absolute worst licensing regime anywhere in the nation. You need one type of license if you're going to try to buy a handgun. You need a different type of license, however, if you're going to just try to buy a long gun. You need an entirely different license if you want to have the audacity to carry a firearm that actually is going to have 4 references, has a lot of high cost to it, and then actually includes some mandatory live fire training. And it's almost as if, when you look at this licensing regime, they're just trying to keep New Jersey residents disarmed. Oh, that's right. That's exactly what they're trying to do. Well, now there is a major challenge that has been filed, and its intention is to dismantle that entire licensing regime in New Jersey. So today, let's slow it all down, let's geek out on the brief, and let's talk about a major challenge to one of this nation's most horrible licensing regimes. Okay, before we get going too far down the road we're going down, proud to announce that this video is being brought to you by Freelance. Formed in 1994 in Washington State, they've been operating here in beautiful Bellingham, Washington for the last 25 years. Hey, listen, they may have started with the Seattle Slug, but now they're specializing in base plates and brass backstraps. They make parts and components for most major manufacturers, and yes, they can make parts for your pistols, your rifles, and your shotguns. Listen, they live by the motto that more ammo is always better. I live by the motto that, hey, they may not make your firearms, but they're gonna make your firearms a lot better. For more information, visit my good friends at taylorfreelancestore.com/WGL. Okay, America, this is what we're talking about today. We're talking about the case of Benton v. Platkin. It is a case that is recently filed. It is brought to us by our good friends at the Gun Owners of America, the Gun Owners Foundation, which means, yes, there are links down below so that if you want to show them some love, you may do so. This is a challenge to several New Jersey statutes, all of which comprise this horrific licensing regime where you got to get one kind of license for this platform of firearm, but a different kind of license for that kind of firearm. And then, of course, if you want to conceal carry or actually protect your own life, then there's a million other hoops to jump through. So the statutes which are being challenged by this lawsuit include New Jersey Statute Section 2C 58-3A, Section 2C 58-3B, and Section 2C 58-4. Now, for those of you who've geeked out with me before, you know that I live by the motto that you never get a second chance to make a first impression. How do the plaintiffs here frame the issue? Well, they frame it really well. And in fact, that's going to be one of the themes of this. I think this is a remarkably well-drafted complaint. There's a couple of summaries that we're going to get to later that I think are just absolutely fantastic summaries. But the Gun Owners of America and all the plaintiffs here start off their pleadings this way. This case involves a challenge to New Jersey's onerous, unconstitutional, and ahistorical firearm permitting regime, along with the state's so-called one gun a month law. For instance, to acquire a handgun, a person must obtain a 2C 58-3A permit to purchase a handgun, requiring, among other things, character references, a background check, payment of a $23 fee, payment of a $25 permit fee, payment of a fee for being fingerprinted, a 2C 58-3F statutory waiting period of up to 30 days to complete the process, another required 2C 58-2 statutory 7-day waiting period, followed by another NICS check, which is not instant, at the point of sale, and payment of another $16 fee. And that is just to acquire a handgun. But guess what? If you're trying to acquire a long gun in New Jersey, as you know, it doesn't get any easier. To acquire a long gun, a person must obtain a 2C58-3B firearms purchaser identification card, which requires its own background check, payment of a fee, a waiting period, and fingerprinting. This permit allows the applicant to purchase long guns without numerical limitation and is valid for 10 years. Okay, and so as you can see, in addition to the licensing, we're also challenging the 1 gun a month. But then, if you've jumped through all those hoops and you've actually gotten yourself a handgun or a long gun, and then you want to actually be able to conceal and carry a firearm with you, guess what? To then exercise the right to carry a firearm, bear arms in public, an applicant must obtain a 2C58-4 permit to carry a handgun, which requires submitting an application attested to by no fewer than 4 reputable persons who have known the applicant for at least 3 years, paying a $200 application fee, receiving in-person firearm instruction, being fingerprinted, submitting to an interview by government officials, providing any extra information the licensing official demands, providing a list of registry of all firearms that the applicant wishes to carry, and of course, submitting to another background check. Can you believe all of that? And as the Gun Owners of America properly points out, in other words, to exercise an enumerated right that belongs to all Americans and that the states shall not infringe, New Jerseyans nevertheless must submit to no fewer than 3 separate background checks and obtain 3 separate government permission slips to keep and bear arms: permission to purchase, permission to take possession, and permission to carry. New Jersey treats no other enumerated right in this manner. Oh, I can assure you, New Jersey, there is no other constitutional right anywhere in America that is treated in this manner. Okay, but then here's another problem, America. You see, even if you are able to successfully jump through all of those hoops, well, then let us remember there's this little time restriction on it. So as GOA points out again, and even if a person applies for and receives multiple permits to purchase a handgun at once, New Jersey limits the applicant to a single purchase of 1 handgun per month. This 1 gun a month limitation on the exercise of an enumerated right lacks any historical tradition, infringes on New Jersey and Second Amendment rights, and is an outlier among the states, as in the vast majority of states, there is no quantity limit of how many firearms the people can purchase per month. In short, New Jersey's purchase permitting and purchase rationing schemes violate the Second and 14th Amendment of the United States Constitution. So I said that I really like great summaries. How can we take very complicated, wordy rules of law and sum it up in its most simplest terms so that any idiot, including some that wear black robes, can understand what is the true test here? The plaintiffs here do an amazing job. They go through all of the cases. They start with Heller, they go through McDonald, they go through Catano, they get to Bruen, and they finally sum up where are we today when it comes to analyzing the constitutionality of gun control legislation. In other words, according to the Second Amendment's text, and as elucidated by the court in Bruen, if a member of the people wishes to keep or bear a protected arm, then the ability to do so shall not be infringed. And it does not matter at all how important, significant, compelling, or overriding the government's justification for or interest in infringing the right, nor does it matter whether a government restriction minimally versus severely burdens or infringes the Second Amendment. There are no relevant statistical studies to be consulted. There are no sociological arguments to be considered. The ubiquitous problem of crime or the density of population do not affect the equation. The only appropriate inquiry then, according to Bruen, is what the public understanding of the right to keep and bear arms was during the ratification of the Second Amendment. That, folks, is absolutely the best summary that I have ever read as it relates to what truly is the test. What was the massive change in the constitutional analysis moving forward as announced by the Bruen court? And again, sticking to just fantastic summaries, when it comes to really analyzing where does the right to keep and bear arms sit today in the post-Bruen world, well, GOA very accurately states the following. The right to keep and bear arms presumptively applies to all Americans, presumptively extends to all bearable arms, and presumptively covers to all locations. Anything limiting that expansive reach must comport with a broad and enduring historical tradition demonstrating that certain persons, arms, or activities were never considered within the scope of the Second Amendment in the first place. And again, I think that is just an absolutely fantastic summary. Now, the plaintiffs also do an excellent job of pointing out to the court, hey, listen, you need to intervene right now because this is a significant problem that is only going to get worse. As GOA points out, because New Jersey law operates to entirely deprive the people of their Second Amendment rights for extended periods of time, this court's intervention is necessary to make it clear to New Jersey that it is not free to thumb its nose at the text of the Second Amendment or the opinions of the Supreme Court, and that the Second Amendment is neither a constitutional orphan nor a second-class right. Now, as some of you may recall, especially if you geek out on this channel all the time, is that similar licensing regimes have been struck down in Maryland, which is actually cited in this complaint. It's Maryland shall issue v. Moore. Then there's another case all the way out on the other side of the country in Oregon, a case called Arnold v. Kotek, which actually reached the exact same conclusion under the exact same set of facts. As the plaintiffs point out here, finding that nothing in the amendment's text or Bruen says that it protects only against laws that permanently deprive people of the ability to keep and bear arms, and that Maryland has identified no other traditions that could serve as a historical analog, nor has it presented any other evidence that the challenged law is consistent with this nation's historical tradition of firearm regulation, the Fourth Circuit held the waiting period unconstitutional, which of course is the exact same ruling that gun owners of America are advocating in this case. And so finally, and kind of the punchline here as to why this case needs to be heard and why the plaintiff's correct, Gun Owners of America points out, New Jersey has one of the most hostile and onerous firearms regulatory regimes in the nation, criminalizing, absent possession of the appropriate permit, almost all conduct relating to the constitutionally enumerated right to keep and bear arms. Indeed, New Jersey has flipped the Bruen Second Amendment textual presumption of constitutional protection on its head, establishing a contrary presumption of guilt, such that when a person possesses a firearm for which a permit is required, as is the case in most contexts, that person is presumed not to have the permit and to have committed a crime unless they prove otherwise. All told, New Jersey's scheme of firearm regulation is one of general prohibition and limited exception. Okay, and then what are the remedies? Always got to have remedies in a lawsuit where they are asking for a declaratory judgment. They are asking that the court enjoin enforcement of these laws. They are asking that the court then permanently enjoin after temporarily enjoining this, and that all of these laws be deemed unconstitutional and unenforceable. The case, once again, is Benton v. Platkin. It is filed in the United States District Court for the District of New Jersey. It is brought to us by our good friends at the Gun Owners of America, which means, yes, there is a link down below so that you can show them some love. Maybe you got questions about this or anything else related to what's left of our Second Amendment rights. If you do, you should know how to get a hold of Washington Gun Law by now, but if you don't, that's okay. That information is down there in the description box. Maybe you got ideas for videos we should be doing here at the channel. Well, if you do, go ahead and click on that link right there. Some of the best ideas we ever had, candidly, weren't our ideas to begin with. And then finally, and most importantly, let's everyone remember, the part of being the lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation, how it applies to you in any instance that you may find yourself. Until next time, thanks for watching, and stay safe.